Our next presenter is Robert Leckey from the Faculty of Law at McGill University. Robert is Samuel Gale Professor and Dean of the McGill Faculty of Law. An award-winning, internationally recognized scholar and teacher in constitutional law, family law, and comparative law, he has advanced knowledge on matters such as law's recognition of traditionally unrecognized family forms, including LGBTQ couples, and judges' techniques in human rights cases. His frequent media appearances contribute to public knowledge and debates on legal issues.
I'm Robert Leckey, the Samuel Gale Professor and Dean of the McGill Faculty of Law. And I want to speak to you briefly about my research on including LGBTQ families in law in Canada. This is just one strand of my work in family law. I could also have spoken about work, for example, on how law has managed to make space to varying degrees for unmarried couples who live together. And my work as a constitutional scholar has focused on a number of issues, including how charter rights are made real. But the LGBTQ work has stretched across a number of years, and I think it's particularly relevant. So it's included a range of pieces. One of them, sort of historically, looked at the discourse around the criminal law's retreat from same-sex conduct in the 20th century. So in the late 1960s, the federal government partially decriminalized same-sex conduct. Pierre Trudeau was prime minister at the time. And what I've traced is the extent to which even the reformers of that time used quite striking homophobic discourse. And once the criminal law had stepped back, it was possible to start thinking about same-sex couples as maybe being treated by law like families. And I've argued that the discrimination claims brought under the Canadian Charter, by which it was found to be a violation of equality in some respects when law didn't recognize same-sex couples, I've shown how that became more thinkable or more possible because there had already been private disputes around property brought by same-sex couples on their breaking up before the charter challenges. So the private disputes laid the groundwork for thinking of same-sex couples as potentially being family. Another key issue is how, if there are two people of the same sex raising children together, how can they be given legal status? How can they be formally recognized both as the parent? And there are a range of scenarios, but at minimum, we would think that there's at least one of them who will not have a genetic tie connecting them to the child. And so I've traced the range of ways, some legislative, some judicial, for granting parental status to same-sex couples. In particular, I focused on bold reforms enacted by the Quebec legislature in 2002 that made it possible for a child to have two mothers or two fathers in the province. And this work led me to look more closely at the relationship between law and social science research on how families actually conduct themselves, how people in families view one another, what their expectations are. And one of the things that led me to this research was that the legal claims brought for law to recognize LGBTQ families are often formed in terms of a call for law to reflect social practice, for law to reflect what's already going on the ground. And I looked more closely at this, and it proved kind of a complicated notion, more complicated than those legal claims would lead us to recognize. And there's a couple of reasons for that. One, of course, is that social scientists themselves don't give us access transparently to some kind of objective truth. They themselves disagree among themselves about what's going on. Another is the sheer diversity of family practices that you find once you start looking. And one particularly interesting figure is the second woman in a lesbian couple, the one who's not the birth mother of a child. Social science researchers found that at times there are dozens of words that families use in their day-to-day lives to call that person, not mother. And so the question is, what is law supposed to do? Is law supposed to make space in its statutes for those dozens of different names? Or is it allowed to simplify and to impose a choice distinct from what we observe on the ground? And another kind of thorny question is, what should legislative drafters do if some of the social practice going on is itself shaped or bears the imprint of homophobia? What do you do if the way families are living their lives is itself a product of their historical inequality? An example here again returns to the woman in a lesbian couple who did not give birth to the child. And so qualitative interviews show that in a number of cases, this person does not identify herself as the child's mother. So the question is that an autonomous choice that should be recognized, or might that itself be a reflection of the homophobia and the practice of erasing that second parent figure in a child's life? And so I looked at different legislative regimes. Quebec, as I mentioned, makes space for two mothers. England's law around assisted reproduction makes space for the child's mother or father, and then a child's other parent. Is it appropriate to recognize an other parent, or is that in fact a lesser status than father or mother? So there are a number of complicated issues around here, but we don't simply translate social science into law. And then a last area of inquiry has concerned the judicial role. And judges, as I mentioned, were at times bold and innovative and creative in making space in family law for LGBTQ families. But once the legislature has done its job in making such space, I've argued that there is a risk that even well-intentioned judges can maybe cause unexpected problems if they continue to act in that creative way. And there may be places for judges to sort of step back and allow people to use the rules that are now enacted into statutes, or sometimes not to use those rules. If people have not taken advantage of the new rules to make families legally recognized, maybe it's not up to the judges to fill in those gaps. So we see a movement back and forth from judiciary to legislature to social practice and researchers. And all these explain why this area is so rich and important.